All right, it's Grant Abbott speaking, and we've got a couple of new solutions for you, which I think you're going to find very exciting. The first one is what happens, and I'm going to leave the other one for a surprise a little bit later on. But what happens when a founder of a family company becomes incapacitated, dies, or becomes bankrupt? I mean, these are typical things that may impact us all. And I remember Tim Munro from Change GPS asked me some time ago, and what would happen in the terms, or did I have a solution in the terms of someone becoming mentally incapacitated through COVID, who would actually run the business? And I started to think about my own position. I'm not too bad because of the last couple of years, we've built in so many automations and documents and all that. Although I've got a huge trail or runway that's coming up to Christmas, which I know you guys will be super excited about. But, you know, at least I've got a really good team around me. And also my legal partner, Tony Anabolis, who is also there to support me as we go down the track. So, and Tim, welcome, Tim. I know you're always there, which is fantastic. So I started to think about and started to look at the alternate director issue, which was quite good, but I've done a lot of research and I'm just going to go in and have a look at it a bit further. But what happens is the next one, then people started asking, well, what happens in the event of death of the company founder or the small business owner? What's going to happen there? And that always raises a huge issue, because if you die and you've got probate, it can take months. And if there's intestacy, they don't have a will, then gosh, that's going to take so long. And then you've got the Supreme Court in COVID, it's not running, you've got this and that. So we've got some serious fundamental problems. And I pulled up these stats from this morning, and you can see, I just did a Google search, how many small businesses in Australia. You can see here, and this was from the Australian government website, 2,065,523 small businesses in Australia, employing less than 19 people, accounting for 97% of all Australian businesses by employee size. So that's a pretty significant, and you'd say, well, obviously this is an issue that no one has really, I think they've thought about, but they've never really got down into the weeds and coming up with a solution for it. So thank you very much for Tim for that, and I think you're going to be surprised at where we've gone. So we can have a look here, and I've pulled this off the web. And we're talking about a successor director versus an alternate director. So a successor director is something that we've put into our company constitution, and I'll show you that a little bit later on in the next slide. But essentially a successor director has a bit more strength than an alternate director. An alternate director is guided under the Corporations Act, where a successor director isn't catered for in the Corporations Act. So it's embodied, built and delivered within the constitution of the company. And so it has a bit more flexibility. So you can see here, do you need to notify ASIC? Absolutely. So both ones, they're directors. So what will happen is that in the event that a person becomes incapacitated, then we have to notify ASIC that that person is resigning, because obviously they can't act as a director. The same with bankruptcy, and obviously if they're dead, we need to do that. I shouldn't laugh these days, it's crazy. But then we'll have an appointment, so it's a resignation or retirement of a director, and we do a 484, and then there's a new director is proposed. Can they assign resolutions circulating, and particularly digital ones? Absolutely. Power to vote at a meeting? Yes, that's absolutely correct. And again, counted as part of the total number of directors? Yes, but alternate directors not, because you've got the original director is there. So they just, what they do is they come in as like the reserve from it. Successor director is different. Once you appoint a successor director, they're there. they're there, and you have to go through the process of removing them, which generally is going to be by way of the shareholders having a meeting. So it's a lot stronger than that alternate, as you can see. The alternate is, again, embodied within the Corporations Act, where successor directors are. Must be a director to act in the role? No. Yes, obviously successor director. And again, it depends on the company constitution. So if the constitution doesn't allow it, then essentially you can't have a successor director. Now, this is an interesting one, and it depends on the constitutions. Ours was a little bit different. But again, you can see, so what we had is where someone's incapacitated, an alternate director pokes its head up. But obviously, the alternate director can't carry on, and that was my flummoxing around the last couple of months around what happens on death. And obviously, the alternate director doesn't carry on through death. So because the person's dead and the alternate director is that reserve. So if the underlying director's dead, it's different. Whereas the successor director, once it's appointed, is basically in there. And you can put a time frame on successor director. And of course, you can always start to have a shareholders meeting to remove that successor director. But the key things about that is that if you've got a successor director, someone's incapacitated, they carry on, they take control. If someone's bankrupt, again, the successor director takes control. Someone dies, then the successor director manages that business throughout the process. And I think that that's really crucial. And it can also apply in the event, the same sort of thing in the event of a trustee company in a discretionary trust. So we can go through the same sort of process. We can do the same thing and have a successor director for a self-managed super fund if someone is incapacitated. However, the problem about that is that the successor director needs to be the enduring power of attorney under section 17A3B. And obviously, if we have a look down the track, if we're looking at taking control of the fund or taking that director's position in the event of the death of that director, the successor director, then provided that person is the executor or the legal personal representative, then effectively that successor director can take control of the trustee company of the self-managed super fund. So you can see the successor director is a lot stronger than the reserving sort of alternate director. So I started off here, but again, have moved my thinking around there. Now, what we need to do is the successor director is obviously top of the tree. So we need to make sure that our company constitutions allow successor directors. So if you're going down this process and you've got clients, again, I'll build out a letter for this, or alternatively, I'm sure Tim's probably got a letter on his great Change GPS portal to send out to clients. And if you missed our email email marketing webinar yesterday, it was a great webinar to show you how to get this information out to clients and give them a call to action. So we've updated our SMSF trustee company deeds, documents, constitution there. And again, thanks Tim, he's basically come in and said that he'll do a letter around it, which is fantastic. So any member who is a director may seek to appoint a successor director as a replacement director. So that's the term in our deeds. So we're looking here is the company constitution. So this is for your leading member SMSF trustee company or just your ordinary SMSF trustee company. Now, if you're going to go in and put in the successor director, then you just got to jump online and then update or upgrade your company constitution, which is very easy under section 137 of the Corporations Act. You just need the shareholders to effectively agree and then throw out the old rules and put in the new ones, which is not a bad idea anyway. So any members of the director may seek to appoint a successor director as a replacement director who's to take the director's directorship in the event of the director's incapacity, bankruptcy, death, or by their own choosing, provided such appointment does not breach the super laws, which is pretty important. Now, for ordinary companies, in clause 45 or rule 45.6, we've got, notwithstanding rule 45.5, the directors At the request of a director, may confirm the appointment of a successor director who should take the director's directorship in the event of the director's incapacity, bankruptcy, death, or by their own choosing. And we'll go and have a look at how that works specifically. So what we've done though is so Tim, does a successor director take on any legal risk as a normal director? Absolutely, because they are a true director. And that's the difference between that and the alternate. So when you get director's insurance, you need to ensure that obviously the successor director is encompassed in there. But a great question. Now, what I've done is I've built the successor director into the EPOA, because if you've looked at our succession guidelines, generally you'll find that the person who's going to be your EPOA is also going to be your executor. So what we want is continuity of business. So for example, if we are going to have dad and then mum is going to be the EPOA, that's fine. But if Max, the son, is working in the business, then effectively what we want to do is we should have the EPOA being Max, and then we want to have the executor being Max as well, which seems to make sense. Or we can have joint, both Max and also, let's say, the spouse, Sally. Now, you can see here, and I'm going to take you into the EPOA now, you can see here, you can actually just build a separate EPOA for the successor director only. So it doesn't need to cover SMSFs, although it would generally anyway if you've got a corporate trustee. But you could have Sally or the spouse doing that. And so you tick that box and just do that one. And then you could do a separate one for this one. I'd probably tick that box as well. So let's just bounce out of here. And then what I'm going to do is I'm going to have a look at, obviously, what we've got up here. We've got I've got a enduring power of attorney here. So I'm just going to relaunch this. Saves me having to retype. And you can see I did that this morning at 7:57. So I'm just relaunching. As an aside, currently at the moment, due to Google Chrome and a cookies issue, unfortunately, our platform doesn't work with Google Chrome. We are getting it fixed, but again, it's how long is a piece of string. So you can see down, you either use Firefox or alternatively Microsoft Edge, which I tend to use anyway all the time, and that you won't have any problems with that. So I've got an EPOA in New South Wales. You'll see that there's no logo on this, and the reason there's no logo is because the forms that we use for the enduring power of attorney are all state-based forms. You're going to see next week, and as I said, we've got a huge big roadmap leading up into Christmas, and it absolutely works brilliantly in terms of COVID. Next week, we've got advanced healthcare directives, which we are rolling out. So we've got quite a long rollout, but next week for each state, we'll be having advanced healthcare directives. So make sure you tune in. For us, easiest thing to do is just get onto weekly webinars, and you'll see that they'll pop up, and then make sure that you, obviously what happens to companies on death, you can watch it now, and make sure that you sign up for, we've done the Moat at least one, make sure you sign up for the living wills or the whatever's coming up next. So I think that's pretty important. Let's just go back and have a look at the document I was working on today. So I've got an EPOA. This is for New South Wales. That's my document in the library. So I've got the principal here. I don't know the date of the appointment, but let's just choose it. They're coming in tomorrow. I'm going to send it off tomorrow. Because it's New South Wales, we need a solicitor to sign off. So obviously we'll get Tony to sign off. So I've got John Smith. Is it so overseas address? No. So you can have obviously overseas EPOAs, but it's probably better if they're in the same jurisdiction. The attorney here I've got is his spouse, Sally Smith. No, it's not an overseas address. The replacement attorney is his son, Max Smith. Now, importantly, for this one, we'll go down the track. What we can do is if John gets incapacitated becomes bankrupt or dies, obviously if he dies, his enduring power of attorney just lapses, which is okay. So we're doing this now. What can happen there is if he becomes incapacitated, Sally can simply say she doesn't want to act as the attorney. So then the replacement attorney comes in and it'll be Max Smith. So that's not a bad little one. I haven't gone down any further. Now let's have a look at the power of attorney. And this applies across, we've got Tasmania, ACT, New South Wales, Northern Territory, Victoria, West Australia, South Australia. So we've got them all in terms of your EPOAs. And that also applies if you've got a combined EPOA and also the will as well. So if we go through, we've got Mark Lennon from the first slide, successor director is appointed on death, bankruptcy, etc. True. So is it correct that director duties, responsibilities that do not apply to nominated successor director until death of the appointing director? That is, I'm assuming successor director can be nominated but not appointed. Yes, Mark. And that's a really great question, and I'll look at that. So what we've got here is I've ticked the box about the replacement trustee for the power of attorney. I've got there do anything that can be on behalf or act as a successor director with the principles of director. So the power of attorney happens upon signing of the document. Does the principal want to revoke previous appointment of attorneys? And then obviously we get the solicitor. Now I'm not going to go through all of these. So what we've got is, I'll finish this off and then show you. So what I need to do is put in the name of the company. So I've got the name Bogan Proprietary, and I'll put the ACN, or I've got two directors, John Smith and Fred Nurk. We'll assume he's got another company, and we'll just call it, obviously you can't do this, but just call it Trustee Pty Limited. And then we've got the ACN, 1, 2, 3, 4, 5, 6, 7, 8. And he's the only director of that one. So I've got two there. Let's now copy that out and have a look. And again, I think, so John, for an SMSF, does an alternate or successor director have to be a member of the fund? No. In fact, if you've got their EPOA, so what we're doing here is we can make, for example, Max, who is not a member of the fund, he can be the EPOA, he can be a director. The same thing on death if he's the executor. So I'm going to have to go and make sure my will has Max as the executive if I want that successor director. Going back to the other question from Mark, I'm going to have to put T's and C's around the appointment power. So what we'll do is we'll have a look at that one there. So I'm just going up here. Again, this is straight out of the New South Wales enduring power of attorney. So what we've got there is effectively you don't need to have an Abbott-Family, obviously an Abbott-Family logo on there, your own logo. So you can see here I've got I, John Smith, appoint Sally Smith as to be my attorney, revoke any previous, which is important, authorise my attorney to do anything on my behalf that I can lawfully do by an attorney, which is personal financial. You'll find that most enduring powers of attorney will only have that one. So this is C and D, are two ones that are special only to, obviously, like your docs. C, I authorise my attorney to act on my behalf from my superannuation fund, including acting as a replacement trustee or replacement director, while this enduring power is valid and I have consented to acting as such. So that could be the case going back, John, even if the attorney is not effectively a member of the fund. Now, D, I authorise my attorney to act as a successor director where the principal as a director no longer able or willing to act as a director through incapacity, death of their own choosing. So the issue there, Mark, is that it is up to the director to say when the successor director is to be put in place. Following that, look, I might even, it might be worthwhile if you think on that. And again, these documents, I've seen a couple of lawyers who'll do these successor director documents for you for $1,200 plus. So what we're doing is, again, one of the important things about our system, like your docs, is we can put things up quickly and we can change things quickly. There's no need to build code. And that's why it's cost us so much to build this preemptive system, which means we're on a journey of continuous improvement, much the same as the Japanese methodology of their continuous improvement. So if we're missing out something, or you'd want to put something further in, or you come across something, particularly when I get to our new surprise document, if there's something extra you need in there, please let me know, because then we can build that into the system really quickly. So what here, we've got a resolution by the company to appoint a successor director in the event of director's incapacity or death. So I've got the purpose of the meeting: to ensure the continuity of company decision-making, the directors seek to appoint a successor director for the current director, John Smith, whether they've lost their decision-making capability, die, become bankrupt, or otherwise chose to do so. So the 4 conditions there, Mark, would be lose the capacity, die, become bankrupt, or they just simply say, look, I'm out of here and I'm putting my successor director into that equation, which can be a great little position in terms of SMSF. Now, importantly for that one, we need to make sure if they are going to be, if we're looking at a trustee company for a discretionary trust, no drama. Trustee company for a self-managed super fund, then John, what we need to do is make sure that it's enduring, that the person taking over is an enduring power of attorney, which is why we're drafting it through there. We've got the directors, John and Fred, and this is their business. And then you can see there, so it's not a sole founder, but he's he's got a major controlling interest in the company. So what happens there is the chairperson table of motion, so Sally comes in. So then we've got the company hereby resolves to appoint Sally Smith as blah, blah, blah. And then we go down, John Smith and Fred Nurk now have signed that. So now it becomes legally binding upon the company, which is important. We've got also another one here. You can see here. So the first one was for Bogan. This is for the trustee company. So then we've got Sally, but John was the only director there. So that's how we've covered that. So through the enduring power of attorney, essentially what we've done is we've covered EPOAs. We're also applying in terms of bankruptcy and death as well. So that's where the successor director applies. So rather than having to set up and do a whole new set of documents, what you can do is you can do successor director straight through your EPOA. So we're combining it all. And as I said, if you wanted to go back and just do it individually, so I'm going back into my vault, which is now found in the dashboard. I'll go in there and have a look. You saw it before, it was Abbott test. So I've got down the New South Wales EPOA. Certainly I would suggest, Tim and everyone else, that you would personally go and put this in place pretty quickly for your own business. Once you've done that, seen how easy it is, you can see if I wanted to, I go to the power of attorney, I can just chuck those ones out, and then effectively all I'll do is I'll just end up with a company. So that's a pretty important one. New South Wales, you're still going to have to get Tony to sign off, which is pretty important as well. Someone said, well, can we get our local solicitor? The problem is if you give this to a local solicitor, they'll have no idea. It's going to cost you $800 just for them to review it. Whereas a good thing about Tony, he's really on top of everything, signing off on wills, day in, day out, and enduring powers of attorney. So that's now in our Moat. It's in our LYD will with EPOA, or LYD will on testamentary trust with EPOA. So that's the particular issue. Has anyone got any questions on that? So Tim, so the date the risk begins with a successor director is only when the risk only, Tim, for the successor director is when they are appointed. So as soon as they're appointed, so the process is the principal becomes incapacitated, they're appointed as successor director because you've got that pre-filled binding resolution there. The next one is if the person becomes bankrupt, successor director dies, successor director there. Alternatively, I'll have a look and I'll have a think about it whether, if you want, we can actually put in some timing, much the same as here. We can put here, when will the power of attorney commence? So we could put in 2 or 3 buttons underneath here. When will the successor director commence? But we do want to have that flexibility that we've got incapacity, death, or their own choosing. So I think we've got it right, because it gives the flexibility. But again, have a think about it. And again, I would love you guys to give me your thoughts and feedbacks. So Darren, in the absence of a successor director and the sole director dies, who actually controls the company before probate? Well, that's the problem, Darren. No one. And that's the issue, is that generally what will happen is that the shareholders have to appoint the director. Now, if it was, for example, in this instance, John owns all the shares, then effectively you're pretty well stuffed in that instance, because you're going to have to wait for the executor to start control all those assets and get probate. So that could take 3, 6, and if it's contested, it could take 12 months. And if it's intestate, can you imagine the disaster that could end up? The other one that you can use, Darren, which is quite useful, is to use a leading member company. So if you've got a discretionary trust, if you've got a trustee of an SMSF, a leading member would be John is the leading member and controls all the shares. When he dies or becomes incapacitated or is bankrupt, his shares are cancelled, and then they're transferred down to the next leading member, who in this instance would be Max. So if you're using that's a really good strong one, but that doesn't help if you're in a business itself. So if it's in a company, unfortunately, you're in a bit of strife, which is what this solution is for. And you can imagine, Darren, you've got 2.3 or 2.6 million people. What have I got there? So, so we've got there, you can see over 2 million small businesses who are severely at risk at the moment. So for Nishith, can a husband appoint a wife to be appointor? Can wife appoint husband to be appointor? So if we're looking at the appointor for the trust, let's go in. That's a great segue. I'm not sure how you work that one out, Nishith, but it's perfect. So a little bit of a drum roll. So now, if we have a look here, so this has come around a lot. So we get a lot of requests. In fact, I get at least 3 or 4 a week. So we've got on our site how to change trustee. So from individuals to corporate and individuals to individuals if you need to. But we get requests. What happens if there's a family breakdown, a divorce, separation, or just change of circumstances, so that inside our family or discretionary trust, we might need to change the name. We might need to remove beneficiaries. We might need to add beneficiaries. We might need to remove, or we might need to add a trustee. The question there from Nishith, we might need to remove, or we might need to add an appointor. The same thing with leading members. If you've got a leading member trust there, so if it's a leading member discretionary trust, and the same one for some old trustees, you'll find principals will be in there. So the more we find out, the more we can build it. Now I can tell you, it's been so hard to build, because when you have multiple parties, you can find, if you went and took this to a solicitor, it's going to cost you, honestly, thousands to build it up. So I've been working on it for a long time, and so we're releasing it through one document. You'll be able to do all of this stuff, and that's quite amazing. You're not going to use it every day, but just to know it's there. So this is like our all-purpose, all-complete, comprehensive change in discretionary trusts for beneficiaries, appointors, principals, leading members, and even in the name. Now, I can blow it out even a bit further, but we're going to take you in and show you what it looks like. And I'm going to do a case study around it. Now, the important thing is, you've seen me talk about it before, but the ATO tax determination 2012/21 looks at CGT. Is there a CGT event for changing name, beneficiaries, trustees, appointers, so on and so forth, and even changing the vesting date, provided, of course, it sits within the 80 years. And in there's no CGT. The Commission also goes through and looks at the law around settlement. So when it comes around resettlement, again, all of these things will not be a resettlement according to the Commissioner's guidelines. So we've just got another question for John. So for an SMSF, does an alternative successor director have to be a member of the fund? No, not at all. So if, for example, we can't put, unfortunately, a successor director if the person's bankrupt. There's a special rule about that. And so what we need to do is effectively be in a position that if they're mentally incapacitated, then if they've got our enduring power of attorney, which is why we've done it in there, then that successor director will be able to take our place as director of the corporate trustee. And effectively from that position, they don't have to be a member of the fund. So John, you could easily, if you had my enduring power of attorney, you would be able to effectively be a director. Our company constitution for SMSFs is important because not only, and this is really important where we're going to, not only would you be my successor director, we call it a replacement director for SMSFs, but you're the only one who's able to vote. And we'll be talking about that a little bit later on down in our runway of documents to be released, where we've got an SMSF living will, which means that obviously if I've got a pension, I've got also accumulation, you're the only person who can work out how to spend that. So we're going to put some terms and conditions, much the same as we have a binding death benefit nomination. This is a binding living will nomination. So what will happen is it binds the trustee of the fund on how that money is to be spent. But John, you would be the only one to do that. Now, if I then pass away and you're my successor director, but you are my executor, then you can come in and take control again as my replacement director, and you're the only one who has votes in terms of the distribution of my death benefits according to an SMSF will. Can there be a successor of the successor director? That actually is a really good question, and I think I will actually put that in. You'll find the way we've done it there is I'll have to go in and change my resolution. But if you go in and have a look at remember when I looked at the EPOA, that the initial successor director was Sally, and then it went to Max. So what I need to do is I might beef up that, I'll beef up that successor director resolution. Remember the company one, and I'll put in there any successor to the successor. So it's an easy change. And again, part of continuous improvement. Thank you very much for that, John. I will do that after this session here. So let's go in and have a look at a simple case study. So I've got John Smith's the appointor of the Jolly Discretionary Trust. His now ex-wife Sally was trustee and also a beneficiary. As part of the family law court order, Sally has to be taken or removed from the trust, both as trustee and also beneficiary, which seems to make sense. John wants to change the name to the Smith Family Trust and bring his new girlfriend Janet Jones in as beneficiary and also trustee. John also wants to make his son Max appointor, just in case John needs to relinquish control of the Smith Family Trust due to bankruptcy, dementia, or death. So let me just jump out of here, and then what I'll do is I'll go in and have a look at our new session. Again, remember we've got this one here. I've got my replacement attorney here, which would be my successor for my successor director. So I'll need to just make a couple of changes there, but good question there, John. So let's move on and have a look at our document categories. We're going to go down, obviously, into trusts. You can see here there's a new one here. I've got a change of trustee for discretionary trusts, which we effectively can use that one. We've also got deed of succession appointors, if we've got a chain of appointors. We've also got here addition to designated beneficiaries. But these are all specific and very tiny elements. So what I've done is I've pulled them all into one document, changes to discretionary trust positions and the name. So again, I'm unlimited, so I'll start the document. In fact, it was funny, I was doing a demo yesterday for someone, And I said, look, I love all the stuff you're using, but we haven't used you because it just doesn't seem right that you're so cheap. I'm going, well, I can't believe that one. I thought, well, should I raise my prices for pay as you go? But then I thought, well, no, not really. It's because the system we're using, when we're at Now Infinity, I had 35 developers working on the system. Here, I've got one template developer who's a brilliant guy. He's probably one of the best I've seen, who lives in the Philippines and works for us exclusively. So the reason we're so cheap is that our costs are so low. In fact, our whole business only runs with about 5 people. And that's, again, we want to make sure we have some great support there. So let's go in here. So we're going to put it the Smith Family Trust. And again, you can see I'm using Edge here because there's still problems. Now I'm going to put in the Abbott-Family logo there. So the general. So what is the full name of the trust? Remember, that is the Jolly Discretionary Trust, I think. Let me just make sure I get all the stats right. I'd hate to come back and have a look. So it's the Jolly Discretionary Trust. Thank you. So I'll just make sure that everything is okay. So we've got the Jolly Discretionary Trust. What is the date of the deed to change of position? So we'll just make that tomorrow. When was the original deed established? Because this is going to be a variation to the deed. So I'll put 2012. Does the trustee want to change the name of the trust? Yes. We're going to make it the Smith Family Trust. And then we're not going to make the date of change. I'm going to make that from 1st of July. So it's going to cater for the year. So I'm doing a bit of shifting there. Okay, so we've got to put in the trustees' details. So in fact, what I'll do is I'll make them individuals. So I've got John Smith, 5 Smith Street, Sydney, New South Wales, 2000. And we've got another trustee. She hasn't been resigned as yet. So that is Sally Smith, who hasn't changed her name yet. So she's at 100 Brown Street. Beautiful place. Fairlight. I don't want to have too many caps. So Fairlight, New South Wales, 2095. So I've done the trustees. So both of them are trustees of the Jolly Trust. Okay, so we've got the changing party. So what I've got there is I've got the Sally is the trustee and also the beneficiary, and she's going to retire. She's an individual. So I probably need to put in some common parties here. So I might change that. I think if for those of you who know using wills, you know what common parties are, just to make things easier. Oh, sorry, she was at Fairlight 2095. So let me just change that one. Fairlight. Okay, so that's the first one. So we've changed the name here. We've gone into Sally, who's the trustee and the beneficiary. We're retiring her. Now I'm going to add another. So what I've got there is I've got a new beneficiary and trustee who's going to be new, and they're going to be an individual. So I've now got Janet, I think it was Janet Brown, just let me check. So Janet Jones, and I'm going to make Max a pointeur. So I'm just making sure I give you everything right. So I've got Janet Jones, and she's at 5 Smith Street. I'll get some selects here as well, just make it easier. Okay, and I've got another one which comes back to that issue before. So I've got an appointeur, and I've got a new one there, and it's an individual. And you can see you can put company appointeurs if you want there. So Max Smith, he's still living with his dad in Sydney. Okay. And then what I need to do is I need to go into the deed. So what clause of rule an existing trustee provides for a change of appointor? So I'll go into the deed and I'll find out it's rule 5.1. So who's actually to provide the consent? Let me just check. That'll be the appointor. What clause or rule in the existing trustee provides for a change in trustee? And again, it will be 5.1. And which party is required? That's going to be the appointor. And a change in beneficiary is 3.1. I've gone in and it's going to be the trustee. And I think I might have just, in fact, let me just go in because I think I'm going to have an issue about the appointors, but I can change that pretty easily. So I go and have a look at the document. And again, please go and use this yourself, try it out, because as you can see, the number of permutations that this will throw up is quite significant. But it's a good, all purposes, very strong document that essentially we can use. And again, it's taken me weeks to effectively do this because it's just, it's a bit of a beast. And I think I'm going to get caught on that appointorship. But we've got a deed of variation for the discretionary trust, the Jelly discretionary trust. We've got our AM sign off there. So the deed of variation, so you can see here, every time I ticked a box of doing the appointor, trustee, beneficiary, and name change, I've got the deed. So we've got the trustee, so it's John and Sally, which is important. Now, again, I could change the trustee to a company if need be. So rather than using that change of trustee that we saw before, use this as your go-to because generally there's going to be some major changes. So changing the appointor, so I've got Max as the new appointor, there's no retirement. Changing the trustee, so we've got Janet being the new trustee and Sally being the retiring trustee. Changing beneficiary, Janet and Sally's obviously out. So the trust was established by deed dated blah. Trustee has been notified they've changed in various trust positions and the trustee seeks to change the trust name. So the recitals above, they're all incorporated as part of the operative provisions. So the new appointer is appointed by the trust by the appointer pursuant to Rule 5.1. What I've going to have to do here is just excuse me. After this, I'll make a change pretty quickly. But where someone ticks appointer, I need to put in place the existing appointer as well. It'll be John Smith. But look, that'll be fine. That's easy to change. So the new appointer is appointed as appointer, as appointer of the trust by the appointer pursuant to 5.1. The new trustee is appointed trust by the appointer. The retiring trustee hereby resigns trustee pursuant to Rule 5.1. The new beneficiary is appointed beneficiary. The retiring beneficiary hereby resigns, blah, blah, blah. And usually they're the same clauses. The trust name is a change from Jally to the Smith from the 1st of July 2020. All parties by execution of the deed accepts to be bound and there's no resettlement. So I'm going to boost that up again with a little thing. So, and then we go through the sign as a trustee. Now, what I'll do is I'll go in and make a change straight after this around the appointorship. So that'll be up, be up in a couple of hours. We've got the new appointor trustee beneficiary. So we've got Janet Jones there. And then we've got Max Smith, retiring trustee beneficiary. We've got Sally Smith as the trustee and the beneficiary. And we've got Max as the appointor. And you can see there as, well done, we've got Janet as the trustee and beneficiary. So rather than have, originally we had like monster amount of signatures, but here we've got it all in one. So that's essentially our comprehensive. So we've got here, can you change, Nishith again, can you change the unit holder unit trust once the original has departed and separate docs exists, the evidence, the retirement? You can't change a unit holder through this, although let me have a think about that one as well. Maybe put in our support what you're getting at exactly. So just put in there the support, what you're getting at exactly in the Nishith, so I can have a look. There's been a number of trustee variations. So you need to show each of these in addition to the original trustee details. Generally, that's the case. It's the best. So what I'll do from this Steve D is I'll also put in those extra trust variations. Again, you can start to see you guys are in here helping me. I'll make the changes for the appointor, those trustee variations, so you can put them in Generally, you're just going to have to look at the last variations just to make it more circumspect. But I'll do that very shortly. As you can see, it's a pretty comprehensive document, and with a variation for the unit trust, what I'll do is I'll make a similar sort of document as this for variations of the unit trust. So that'll be a great one. But anyway, we're sort of at the end of the day. What I want to do is show you what's coming up in terms of our runway, just so you're aware of what's coming up in. Let me just go here, Zoom. I'll just go in and have a look at some of our webinars that are coming up. So I'll go to my account. Sorry about the size here. Let me just bounce that up a little bit further. 75% is a bit low. So go to the webinars. Just be careful you're on top of everything. I'll go to the webinars. You can see here, we've done the death of the founder. So that will now go up onto our site. Next week is advanced healthcare directives. The week after that is the enduring guardianship. So who's going to look after you in the event that you do become incapacitated? Who's your guardian? Remember that living wills, the binding SMSF directions. So that's an SMSF living will. That'll come in the week after. Then for strategists, I'm going to be doing a huge case studies around that. We're going to spend 2 or 3 hours on that. So you get a really good understanding of how to put all of this stuff together. On the 17th of September, we're going to look at the living trust. So essentially here, what we're doing is looking at building a trust, a family protection trust or a leading member trust, so that we don't have assets outside of our trust in the event of our death. So everything gets parceled into this. So it's what we call an in vivos trust. It defeats the will. So we don't have the problem with a lot of this. We're looking at income streams coming up. We're going to look at this one. Make sure that's in your diary. That's a 4-hour session on the moat and the castle. So that'll be about 3 or 4 case studies on that. It's 4 hours, but certainly well worthwhile. Loans and lending agreements, 8th of October. Consumer protection, so that's mainly stuff we're going to look at in terms of your CPD. We're going to look at lease agreements, commercial, residential and rural. So rural lease of farm leases will be released on that date. Asset protection case studies. In between that, we're obviously going to be releasing a lot more as well. But look, thank you very much for your time today. As you can see, we've got a lot going on. And more importantly, from our perspective is, look, we are, so Phil, what happens when an ex-wife does not want to sign? Effectively, then you can have a look. If it's a trust, it's a tough one. The ones I've dealt mainly with are family law court orders, so the wife has to sign. The other one is, of course, if you are the appointor, then what I would do is I'd simply boot both the trustees and put in place a corporate trustee, which would simply be the new trustee. So that's the way to get around that. And particularly, again, the benefit of having a leading member family trust is the way to go. So just simply remove them is the quickest way. And I can tell you that from practical experience. So let me go back and have a look at those changes. Thank you very much for turning up today. And look, it's going to be a really great look. That one blows my mind, but again, it's very practical for a lot of our clients. Anyway, it's Grant Abbott signing off, and make sure.
You there?
Yeah, make sure. Yeah, sorry, Tony, you want to have a quick word?
Yeah, just a quick one. Hi, everyone. Just wanted.
This is Tony Anamoulis from Abbott-Family.
Hello, guys. I just wanted, just before we get off very, very quickly, is what I want to do is propose a workshop, maybe in October, November sometime, titled 101 Estate Planning for Advisors, which will take you through the administration process. And it's good for you guys in any case personally, so you know what the administration process is in relation to the estate planning stuff and what we're doing and how we're going to tie it all in, basically. So I think that's a good idea, Grant, don't you think?
Yeah, definitely. So what we'll do is, I know I've seen his course, so we've done that basic wills training, but we are getting a lot of people just saying, look, we're just putting our foot in the water, particularly a lot of financial planners. And this is the great space. I mean, there's $3.2 trillion. I mean, how many, all of you have sent clients to estate planning lawyers. How many of them have actually come up with a solution for successor directors in the event of death? And I would say none of them. So, we're always thinking and innovating in that process, and anything we can help to support you and make you better advisors. And again, as you can see, all of our training, our CPD, particularly the Wednesday ones, which are the deep divers part of the strategist. But a lot of our CPD is included as just being a member of the Like Your Docs family. So absolutely, Tony, let's get that going.
Yeah,
And
sure.
probably I think a good rollout would be early October, if that's okay for you. In fact, maybe late September. You can see there's a bit of a break there. So maybe around the 25th of September or the 24th or the 23rd, because that will then enable us, once you do all that, once you get to this moat and the castle, it's going to blow your mind. I'll show you what it looks like. This is just a preemptive. I don't want you to get too carried away. This is something I've been working on for a lot. And we've got some good establishment packages coming up as well for... actually, it's not Like Your Docs. Let me just go through. So let me go through. Where have I got it? Oh, there we go. Hot Docs, sorry. So I'll just show you the moat and the castle. So we've got some new packages coming up too, which will be establishment packages for SMSFs, which will include the SMSF corporate trustee, as well as the investment strategy and also a basic binding death benefit nomination. So if we just go in, this is where we need to get to. I'll just show you the moat and the castle. Okay, you can see that one. So some of you have a look at the moat if you haven't looked at it before, but this is the next level on. So again, this idea of common parties, I need to start building this in. The moat and the castle, it's got to be updated for Protector, but the documents it does, it does. So it does the Protector. It does your enduring power of attorney. You can actually build discretionary trusts or leading member discretionary trusts if you want from this in companies, which will flow into the Protector. Obviously, if you're doing your EPOAs, you'll be able to do that successor directors in there. You can upgrade your SMSFs either to basic one or to the leading member, which is my preference, and obviously the corporate trustee. You can do a family allowance agreement, which is really, that's pretty important. So again, all of these, you can upgrade all of those ones. You can do a family allowance agreement, a dependent declaration as well. So that is to ensure that families can be treated as dependents for tax purposes in the event of death. SMSF will, which we're going to be going through. Pension, so that, for example, if you want to add multi-generations to a pension, we can roll it back and start again. And if you haven't seen my webinar on how to do some sophisticated estate planning with reversionary pensions, go and have a look at that. And then the wills and testamentary trusts. So essentially, we've got everything in there, upgrading. So it's the whole box and dice. It is the full moat and the castle with boiling oil and alligators sitting inside. So this is your go-to for most small businesses. Anyway, we'll be looking at that coming up, as I said, early in October. We'll be doing a half-day session on that. But anyway, thank you all for turning up. Make sure you just keep in touch. Again, we're here for you. Use that support button. But in the meantime, if you need help from myself or Tony, just contact us at any point in time. So thanks for turning up, and we'll definitely get that wills training session up and running. Tony, it'd be great.
Fantastic.
Okay, thank you.
Thanks, guys.